Our next panel is Protecting Human Rights Through Economic Sanctions and Supply Chain Due Diligence. The moderator of our panel is Lawrence Herman. Larry is a member of our executive committee, and Larry has practiced international trade and investment law and policy both inside the government and in the private sector for over 45 years. He was a member of Canada's mission to the United Nations and the General Agreement on Tariffs and Trade in the 1970s, and in law practice has acted as counsel for Canada in the International Court of Justice and has advocated cases before the Canadian International Trade Tribunal, binational panels established under dispute resolution provisions of the North American Free Trade Agreement, and Canadian courts. He advises governments, state agencies, and international organizations on trade and investment. He's a member of the North American Forum, the Canadian government's Trade Negotiation Advisory Committee. He's chair of the Canadian International Trade Tribunal's National Advisory Committee and is a senior fellow and National Policy Council member at the C.D. Howe Institute in Toronto. He's a known commentator. He appears regularly on TV and also in the Globe and Mail, the National Post, and other publications. He joined the law firm of Cassidy Levy Kent as special counsel in 2019 while maintaining his independent practice of Herman and Associates. So here to introduce this panel and to moderate it, Larry, it's yours.
Thank you, Steve. We've heard broad policy issues, public law issues about economics and human rights, and that's the subject of this conference, the economic intersection with human rights. And now we're going to drill down a little bit. We're going to talk about the human rights issues in respect of sanctions, which is a burgeoning part of law. And for you students who want to practice international law, let me tell you, sanctions is a major component of international law practice today. I mean, when I started practicing international trade law, sanctions was a small part of the business. Today, it is huge. And so you who want to practice in this area better pay attention to what these two eminent persons are going to discuss. I wanted to just to set the stage a little bit before I more formally introduce John and Rick. When we talk about sanctions, we're talking about more than the traditional kind of sanctions that were applied by governments years ago in the 19th century, in the First World War, etc. Those were what we would call traditional kinds of sanctions and blockades. And sanctions as a notion, as a legal conception, have expanded enormously, as I just said. But included in the whole concept of sanctions are not just the traditional kind of sanctions through government regulation, but tariffs. Tariffs are part of the regime of sanctions. Tariff surcharges, for example, and we've seen those applied widely in the last few years by the U.S. government in particular, but other governments in the Allied area and the G7, etc. Import restrictions, that's part of what we would call, quote, sanctions. And we know how import restrictions have been applied with respect to Xinjiang in China and blood diamonds, for example, where governments prevent imported products that are made in regimes that abuse human rights. Export controls are part of the sanctions regime. And investment restrictions are now also used as a sanctions mechanism. I might also add, and I think we could have a good discussion about this, latter subject because it was raised previously. There's a whole range of non-governmental areas in the corporate social responsibility and ESG area where corporations, because of investor pressures, are engaging in trade restrictive measures when it comes to human rights abuses abroad. All of these make up the mix of what we call sanctions. And what we are going to address today is whether they work in terms of protecting and enhancing human rights. What are the day-to-day issues that companies, because we're really talking about companies engaging in international trade and business, deal with sanctions, and how Canada and the U.S. cooperate in the development, implementation, and enforcement of sanctions. So as I indicated, we have two of the best. And that's what the Canada-U.S. Law Institute likes to do. We like to present to you the best in the field, and we've got two of the best right here. Rick Newcomb, partner in the well-known international firm of DLA Piper, has been involved in sanctions for many, many years. He's eminent in the field as a practitioner, but before he went into private practice, he was in the Treasury Department, and he was director of the Office of Foreign Asset Controls, OFAC, in the Treasury Department. They develop and implement the whole range of U.S. sanctions, and Rick was there for almost 20 years before he returned to private practice, and his involvement in this area is renowned. We're happy to have him with us today to talk about the U.S. experience. John Buscariel is a senior partner in the well-known Canadian firm, the eminent Canadian firm of McCarthy Tétrault. John's practice has been renowned for dealing with international trade, and he's in recent days he's appeared before parliamentary committees on the whole issue of sanctions. He teaches international trade, including sanctions, at Western, which is one of the anchors of this institute. He's been a well-known author and commentator on the whole range of issues we're going to address today. So, as I said, we have two of the best. And we're going to start with Rick, and then John will follow. And I'm hoping that we'll have a good exchange with our participants in the audience. So, Rick, over to you.
Thank you, Larry, for that very kind introduction, and it's an honor and privilege to be here, as always. I'll first provide an overview of the progression of U.S. primary and secondary sanctions over the past several decades as one of the primary weapons in the arsenal of options available to the President in the conduct of his duties in response to threats from outside of the United States to the national security, foreign policy, or economy of the United States. I will follow then and focus on numerous examples where sanctions have been used to address concerns about denial of human rights to persons in many countries around the world. The history of the use of economic sanctions by the U.S. in the conduct of foreign affairs is rich with an abundance of examples as a tool, primary tool in U.S. history, well over 100 in number, perhaps 150 in number. The U.S. had led this effort over the years and has developed the tools and allocated the resources to build the administrative apparatus and support structure to make the use of sanctions as an effective option for the President when world peace, human rights, and dignity are threatened, consisting of the following key components: a strong and coordinated domestic enforcement program involving many agencies, strong compliance by major corporate financial institutions, well-staffed and experienced administrative body capable of carrying out what the presidential mandate through the issuance of regulations, guidance, and strengthen the parameters for each sanctions program and commitment to enforce those measures. An ever more effective use of intelligence and law enforcement assets and resources. A strong legal foundation with effective and flexible laws. Support, encouragement, and often the direct involvement of the U.S. Congress and new legislation and oversight when needed, sometimes when not needed. Wide deference by the courts to the executive branch in carrying out its foreign policy and national security objectives. Strong executive branch political involvement, up to and including the president. Stable and dependable currency, and this is very important, that the world relies upon as the currency of choice in international trade of goods and services. The U.S. has all of the above and has enabled the U.S. to use its jurisdiction over U.S. persons with primary sanctions domestically and its economic strength to impose secondary sanctions extraterritorially. To be clear about the distinction, primary sanctions is the assertion of U.S. jurisdiction to U.S. persons wherever in the world located, or any person in the United States. Secondary sanctions are a menu of options available to the President under the International Emergency Economic Powers Act, the primary implementing statute, and other related authorities, including especially and most effectively the use of the Foreign Assets Control Specially Designated National Program, that is the naming of specific non-U.S. persons or entities acting for or on behalf of a target country, person, or entity, or the threat, and the threat is critical, of so naming non-U.S. persons as called SDNs if they conduct otherwise lawful transactions with SDNs or target governments, entities, and so forth. The practical effect of this threat is to make the OFAC program extraterritorial by forcing non-U.S. entities to cease transactions with such persons or run the risk of being cut off from all ties with the U.S., including especially the so important U.S. financial system. Other lesser steps from the menu could be taken, but the threat of designation and the loss of access to U.S. financial markets by being blacklisted as an SDN is what creates the desired chilling effect. World trade in goods and services is conducted primarily in U.S. dollars. Non-U.S. international banks rely heavily on access to U.S. correspondent banking relationships. No multilateral financial institution or corporation can run the risk of being cut off from the U.S. and the U.S. economy. Thus, we have secondary extraterritorial sanctions. Many of the issues discussed, the issues related to modern economic sanctions were first tested under the Trading with the Enemy Act, the predecessor statute relating, it's clear back to World War I. This include programs like Cuba, North Korea, Vietnam, Cambodia, China, and the German-Japan Axis in World War II. Over the years, the courts established deference to the executive in carrying out U.S. foreign policy and national security with respect to economic sanctions. They have evolved, developed, and expanded under the International Emergency Economic Powers Act, which was enacted in 1977 during peacetime. First, the U.S. Congress specifically conferred upon the President broad authority to declare a national emergency because of the threat, and then to confer upon himself very broad authority to define the emergency and declare what steps he would take. It requires consultation with Congress, an annual report, and annual renewal. The same can be said about national security and the economy. The President sets the foreign policy. He can determine what threatens it. The President under IEPA has virtually unfettered authority to conduct foreign affairs as he sees fit by this declaration, but the Congress never contemplated such a sweeping use of presidential power to deal with trade issues over the traditional use of legal authorities. That's a whole separate discussion, which I won't get into. The first test of IEPA occurred with the Iranian hostage crisis in 1979 when 52 U.S. nationals were taken hostage. First, on the resounding success of this program effort, there followed a series of IEPA programs: Nicaragua, South Africa, Libya, Iran again, Panama, Sudan, Syria, Iraq, Kuwait, Burma, narcotics traffickers, and terrorist organizations. A new phase in sanctions developed following the heels of 9/11. President Bush declared comprehensive economic sanctions against a new enemy, Osama bin Laden, Al-Qaeda, and other terrorist groups acting worldwide, what was soon described as the global war on terror, called upon the Treasury Department and OFAC to administer them. Working with other key elements of the government, law enforcement, intelligence, diplomatic, military communities, and very clearly and closely with U.S. allies, the financial war on terror sought to disrupt the flow of funds to business relationships and transactions of any nature, whatever, with terrorist groups, their members, and support structure. When members of the congressionally mandated 9/11 Commission issued a follow-up report in 2005, after I had departed from the Treasury Department, on the U.S. response to the attacks of September 11, 2001, in its global war on terror, it graded the five government elements: military, law enforcement, intelligence, diplomatic, and finance. Of these 5 elements, the financial war on terror got the highest grade, an A rating. The other 4 received scores ranging from B to a failing grade. The Bush administration got the message, and became particularly aggressive in the use of sanctions. Given the success after 2011, the high marks from the 9/11 Commission, efforts were redoubled under Obama, Trump, and Biden administration, which have used sanctions as the primary tool in the conduct of U.S. policy, reaching new levels in the sanctions against Russia involving its invasion of Ukraine. The U.S. has also used its broad powers under IEEPA to impose sanctions on countries with specific persons in those countries for having committed serious human rights abuses that are often described in various different ways. For example, violently suppressing peaceful protests, forced labor, child labor, human trafficking, surveillance and internet freedom restrictions, unjust imprisonment of minorities for indefinite periods in internment camps with overcrowding, sleep, food deprivation, medical neglect, physical and psychological abuse, torture, forced ingestion of drugs, forced sterilization and abortion, sexual abuse of religion, of forced renunciation of religion, and denial of use of native language. I'm taking these from the presidential executive orders issued for each one of these programs. And there have been many such programs promulgated and implemented which the U.S. in whole or in part targeting such activities by governments and persons and companies in Burma, the Central African Republic, Congo, Iran, Syria, Mali, Nicaragua, Somalia, Sudan, South Sudan, and China, or for in particular its treatment of certain minorities in the Xinjiang region. I can't stop there without also mentioning the Global Magnitsky Act, where the President of the United States has very broadly delegated authority from the U.S. Congress to, on his own initiative without special legislation, to blacklist any person or to put the name on a list, in the OFAC SDN list, considered responsible for corruption or human rights violation. A truly remarkable unilateral action provided to the President without any of the safeguards of IEEPA, perhaps the broadest expansion of U.S. presidential extraterritorial power there is. The typical way this works is the President uses his authority under IEEPA to identify a country where human rights violations are occurring, and then he delegates to the Treasury and State Department to identify the names of persons or companies involved, primarily a blacklisting process. When the names are identified and placed on the OFAC SDN list, which may be of uncertain enforcement impact, as many of the names may not have any involvement whatever with the U.S. financial system or corporate structure of the U.S., lack of leverage. Accordingly, listing names of persons from third world countries would have limited effect on persons not involved in the U.S. economy or corporate system or financial system, and thus impact on the target group or countries. This is often a problem involved in unilateral sanctions and to sanctions programs limited to as many as many have been to only the naming of names on the OFAC SDN list. Multilateral, there are better ways to implement such programs, such as multilateral programs through an international body where possible, such as the UN, the OECD, other like-minded countries, the UK, the EU, the UN, Canada, and Five Eyes countries. Broader enforcement by other U.S. federal agencies. There's been, in the case of Burma, especially effective with regard to the Xinjiang province, where the implementation specifically involves 6 federal departments and agencies: State, Treasury, Commerce, Labor, Homeland Security, White House Office of U.S. Trade Representative. And they clearly all have a legal enforcement role to play in this activity. There's similar guidance like this for Burma and for Sudan. Together, this group has issued this guidance to the business community of what each person will do and what U.S. businesses can expect and should do to ensure it doesn't run afoul of the sanctions effort. Sanctions for human rights abuses can and do work when they are made to work, meaning they are enforced, multilaterally preferably. There are 2 such programs I'll cite where economic sanctions have been particularly effective and very successful in bringing about badly needed change in horrible human rights situations. First, I'd mention the Comprehensive Anti-Apartheid Act of 1986 that targeted those persons and industries involved in the perpetuation of apartheid in South Africa. Second, I'd cite Serbia, where under the regime of Slobodan Milosevic for the policy and practice of genocide against ethnic minorities with the country and region leading to the Balkan War. In both situations, where the reason that the U.S., working closely with their allies, were able to successfully address the problem and bring about the requisite change. In closing, I want to give one example. Slobodan Milosevic so accurately and angrily stated to a colleague of mine at the U.S. Treasury at the Dayton Conference for the Peace Accords, which involved the ending of the hostilities in the Balkans, as he repeatedly poked my colleague in the chest with his finger, saying, "Sanctions is why I'm here." The greatest admission there could be that they do work effectively when made to work. There are many other players in this. It wasn't just sanctions. The U.S. military played a clear role. And the program was a multilateral effort, not just with the military, but also the diplomatic and intelligence communities. With that, I'll end and we'll take questions. Thank you.
Thank you. Thank you. John.
Thank you, Larry. A few themes I want to touch on for my 13 or 14 minutes here, and I know Larry's going to be a great taskmaster in making sure I stick to that. First, I want to mention just how grateful and humbled I am to be speaking here. I attended this institute's program as a young lawyer and a young student in what you young people these days would call the late 1900s or last century. Have always had a fantastic experience in participating in these proceedings. And a quick note to the young people, the students, the younger lawyers in the audience, this area we're talking about today, where there's this meeting or collision of human rights and business, is one of the most fascinating areas of practice to be in. So whether you're in academia, working for an NGO, working at a law firm, working in government on the enforcement side or the prosecution side, it really is a fascinating area. And I'd encourage you to ask questions and participate after our few minutes here are up. I'm naturally myself an introvert, so when I was in the audience back then, it took all I had to ask questions, but I did, and I was happy I did, and then I saw my name in the proceedings on that little book you have on each of your tables, and was even more a bit flabbergasted about it. But please ask questions and comment. This is, as I say, a really fascinating area for us. I wanted to just mention a couple themes arising from the last panel. I think in Professor Sarah's presentation and some of her responses to the questions, it really hit the nail on the head in terms of where we are in Canada on these issues. She had mentioned that the core has no teeth. I think she also alluded to the fact that regulation of business is a key component here. It's not the only component, but you can have the best treaties. You can have states willingly sign on to those treaties. You can have states domesticate the obligations in those treaties, but without encouraging or compelling corporate behavior, you're not going to get any results. That's a key component here. And in Canada, that's where we have significantly failed. And I don't mean that we're not prosecuting enough, although enforcement is one of the issues. It's also that these rules aren't being properly administered with transparency and clarity to give guidance to Canadian companies. So that's going to be another theme. That has come to a head with the second Russian invasion of Ukraine in 2022 and the sanctions that followed. From our perspective in Canada, and this may be the case for the United States as well, these are the most impactful sanctions in modern history for us. Not necessarily because they are on paper stronger than others. We have more aggressive and broad sanctions against North Korea. We had them in place, very broad trade sanctions against Iran between 2011 to about 2016. We had broad sanctions in place against Burma and Belarus in the 2000s. But because of the impact on the international community, and more specifically what I mean by that is Russia, unlike any other sanctions target to date for us here, at least in Canada, is fully integrated or was fully integrated into our international financial system, into the international economic system. We are Canadian banks. We're doing business with Russian banks. Russian oligarchs, large Russian state-owned enterprises had businesses around the world, They continue to have significant investments in Canada and the United States. No other sanctions target, at least in our view, has been as integrated into the international system like Russia was at the time of the implementation of these sanctions in 2022. So that also has brought things to a head, I think, in Canada, where the Canadian government has been very aggressive, I would say on paper, probably more aggressive than the United States when it's come to Russia sanctions, on paper. And that's an important qualifier here. We've seen it in terms of the companies and individuals Canada is putting on its sanctions list, the nature of the sanctions measures Canada is imposing, Canada's initiative to confiscate and expropriate the assets of individuals and companies that are on our sanctions list. That is a unique measure that the world is watching right now, that Canada has taken, that no other G7 country has taken. I think perhaps the only Western country that has done that may be Latvia. So it is a development for us in Canada that I think is affecting the practice in a really significant way. And I'll come back to that a bit, but the other development I wanted to touch on was this movement over the last, I'd say 15 to 20 years from what is voluntary, like corporate social responsibility used to be a very voluntary concept, to what today is mandatory. Sanctions is part of it, but it's not the only part. Certainly, when we look at human rights, Canada took a huge step in 2017 by implementing authorities under our sanctions laws to impose sanctions against gross violators of human rights, so those violating human rights that was in our autonomous sanctions under our Special Economic Measures Act. It also was with the implementation of our Magnitsky Law. Before that, there was no such authority in Canada. If we were implementing sanctions, it had to be done for purposes of an international crisis or had to be done in conjunction with a group of other states or under a UN Security Council resolution. On the export control side, in 2018, Canada implemented laws that made it mandatory that when reviewing export permit applications, the Canadian government now has to take into account, now has to conduct a review of the impact on international human rights and whether it's consistent with international human rights law, humanitarian law, and looks at the potential, sorry, is this better? Looks at the potential for violence or harm against women or children. Up until that time, that was not a requirement for purposes of reviewing or obtaining an export permit. On the forced labor side, effective July 2020, Canada prohibited the importation of goods made in whole or in part from forced labor. That was put into our law. It was done as a result of our obligations under the USMCA, which replaced NAFTA, but very much at the insistence, I think, of the United States to ensure that what would be diverted away from US shores would certainly not get into the North American economy through Canadian shores or Mexican shores for that matter. I think as was mentioned earlier, we have a new Supply Chains Act reporting regime here in Canada that requires companies as of January 1st to prepare reports. The reports are going to be due by May 31st of this year on the steps they are taking to mitigate the risk of forced and child labor in their supply chains. It's not a due diligence obligation, it's simply an obligation to report what you're doing. Obviously, sunshine being the best disinfectant, that's going to be an incentive, I think, for a lot of companies to want to say they're doing something. These reports are made public. So they're publicly available. They're going to be examined by stakeholders, investors, NGOs. So I think that's another big step on the Canadian part. Again, moving from the voluntary to the compulsory when it comes to these human rights issues. One other point on supply chain due diligence, we're seeing laws in other jurisdictions like Germany, across the EU, where they're imposing a positive obligation to exercise diligence on your supply chain. Not just report what you're doing, but a positive obligation to exercise that. And we understand the Canadian government is thinking about that as well as a possible follow-up to its current Supply Chains Act reporting requirements. So to get back to some of the specific problems or issues we're encountering in Canada, I think for these regimes to work, you have to have cooperation and coordination among countries. Even today, the US can't do it on its own. And we've seen that example with the Russian sanctions where you need more than one country to impose sanctions to make sanctions work. So that's one of, I think, the big lessons learned over the last few years, and certainly it's being put into effect with the Russia sanctions. You also need enforcement. So as I was saying earlier, you could have the best obligations at the international level. You could domesticate those obligations. But if a country is not enforcing those laws, if it's not compelling or encouraging corporate behavior on enforcement, you're not going to achieve the policy objectives. And this is an area where Canada, unfortunately, is failing. So it's that plus the coordination and the listing of parties under sanctions, how that's working. So let me first touch on, I have a few minutes left. Let me first touch on the coordination piece. A lot of lip service is given to coordinating sanctions, and frequently we're seeing coordination between the US and the UK on sanctions, not just with respect to Russia. We saw it earlier this week with respect to Iran in response to the attack on Israel. We're seeing that in a number of sanctions areas. Canada, although it says it's coordinating, has sanctioned a number of parties that are not sanctioned by the United States, the United Kingdom, or the European Union. And in some cases with very, very disastrous results. And just to give you an example of that, I'm not sure if anyone's familiar with the company VSMPO. They're the largest producer of titanium in the world. They're Russian. They've got a Russian subsidiary, or a US subsidiary here that sells that titanium. They are on what's called the entity list here in the United States, which means that you cannot provide US goods or US technology to them. They are not on your SDN list, your specially designated national list, which is the comprehensive menu of sanctions that gets applied to certain listed persons. And there's a good reason for that. They are not sanctioned by any other Western nation. But Canada in late February made the decision to put VSMPO on its sanctions list. No reasons given, no transparency as to why that happened. What Canada didn't realize is the aerospace industry in North America relies on titanium from VSMPO. They're in the blades of engines, they're in all kinds of different aircraft parts. And it's the European supply chain is involved in that as well. But really, everyone here knows the integration between the US and Canadian economies, and particularly in aerospace and automotive, how those supply chains are integrated. Here, the Canadian government went ahead and did that. And of course, all the companies, the aerospace companies and others participating in that supply chain, were in this position now of having to figure out how do we deal with the fact that this product made by this sanctioned party is in the products we produce, is needed for the products we produce. And by the way, it takes 3 or 4 years to approve your source of titanium in the aerospace industry as well. So how do we deal with that? When we went to the Canadian government about this, the message back was they didn't realize that the titanium, particularly that titanium produced by VSMPO, was important to the supply chain of the aerospace industry in North America. And it was shocking to us because we thought there would have been a process they went through to evaluate that and perhaps ask why their allies in the other countries weren't sanctioning VSMPO. So that's one example. I'm going to finish up with a second example, and this is on the enforcement side. Really the administration and enforcement. On the administration side, we still have no significant substantive guidance from the Canadian government on how these measures are interpreted, unlike the United States, unlike the EU or the UK. And in terms of enforcement, we don't see a lot of enforcement out there. And there's a number of reasons for that. I'll get into that probably in the discussion in response to some of the questions. But more often, we're seeing Canadians being charged and convicted in the United States for export control violations or sanctions violations than they are in Canada. So I'll leave it there.
Well, thank you, John and Rick. This has been an incredible discussion about issues of such significance, not only for companies, for businesses who try to find their way through this massive intricacy of sanctions and export controls, but for governments and the challenges on coordination between Canada and the United States and other allies. What I find interesting, and I'd like to have each of you comment, what I find interesting is that quite apart from broad international human rights conventions and treaties, and we heard a discussion about the U.S. not ratifying human rights conventions, quite apart from those broad treaty obligations, there are human rights enforcement mechanisms on the sanctions regime, using sanctions as the vehicle for applying and enforcing, notwithstanding what John said about some of the imperfections of enforcement, but nonetheless, sanctions have become a major instrument in enforcing international human rights standards, quite apart from international treaty obligations in a broad sense. So do you agree with that? And do you have any comments on that? And the other question I have for each of you is this. Fascinating and important legal element of sanctions and human rights is that they are applied by the executive branches in both our governments. The executive branches, whether it's the president or in Canada's case, the federal cabinet, have huge jurisdiction to develop and apply sanctions. And that's an interesting legal factor that warrants some comment. So with those two issues, I'd like to have your reactions.
Thank you. First, with regard to program implementation, I mentioned South Africa and Serbia. There's strong enforcement for all of these programs. When I was director of OFAC, we worked very closely with the State Department, the intelligence community, prosecutors, and others, the Congress. What was so critical, and first let me talk about Comprehensive Anti-Apartheid Act. That was passed and vetoed by President Reagan. That was overridden by the Congress. And so, to his credit, President Reagan said, okay, we're going to enforce it. And enforce it we did because everyone was behind it, because the president said, we're going to enforce it. It made businesses see that this was not good the way it was happening, and a lot of them were start to pull out from the big parastatals. Ford Motor pulled out of its agreement with whatever the name of it was, I've forgotten, it's a while ago. But that presidential involvement was critical. The second I'd mention would be Serbia. This had day-to-day involvement by the National Security Advisor to Vice President Gore, who would personally get involved, like, for example, the killing of Srebrenica. He personally got out and called everyone together. What are we going to do about this? And we want to know. President Clinton would speak up about it as well. Now, we've got all these other programs on human rights. That's really what's going to be required in order to do this. Now, Russia is clearly a human rights issue, but it's got so many other of those issues involved that it doesn't lend itself to the president getting involved specifically for human rights, but the President Biden is involved in Russia. Now, with regard to jurisdiction of the president, IEPA is very, very unique. The president has the broadest authority for him to take whatever steps he wants and needs to take. The State Department pays very close attention to human rights issues in every country around the world. They do a yearly report of human rights. I don't know if it's public or not, but I do recall it's public. Okay, so it's out there, and we know that they know, and they know that we know. I think it's the interest of those parties that are personally affected or have an interest in seeing this kind of leadership involvement. This can be through pressure groups, it could be through the U.S. Congress, it can be through the Senate Foreign Relations Committee. All of them have been involved in the success of these programs that I've mentioned, so I defer.
Yeah, on the enforcement side, I'd raise two issues. One is the structure of the legal structure of sanctions in Canada. There is no civil enforcement remedy. There's no civil enforcement option. So in the United States, you have criminal and civil penalties. Civil penalties can be enforced on a strict liability basis. In Canada, it is only criminal. Now, obviously, it being criminal is important. It's an important signal that how we feel about behavior that violates sanctions. But because we don't have that civil option, the only way you can get a penalty out of a company or individual in Canada who violates sanctions is to have the RCMP investigate, lay charges, convince the public prosecutor that this case should be brought before a court. They have to demonstrate beyond a reasonable doubt that there's a violation here. Court has to agree, find them guilty, or there's a plea negotiated, and then the court imposes a penalty. That takes a lot of resources and a lot of effort on the part of the government to demonstrate something like that. The second issue, and I'm not here to tell the government they should put in place a civil enforcement mechanism, but that's what the UK did in 2022. They're already on that way, and they have civil penalties. And it could be something the Canadian government might think about, or perhaps they are thinking about. The other problem is just the existing resources that they have to enforce this. So Global Affairs Canada has a sanctions division, which is currently being transformed into a sanctions bureau. They were allocated about $76 million a couple of years ago to help build that, along with helping the RCMP enforce. But they are overwhelmed. There is a handful of individuals, and they're very hard workers, they're very bright, engaging people, but there is just a very small amount of them who are handling hundreds of permit applications. With the Russia sanctions and the impact I talked about earlier, there are now, we understand, 500 to 600 permit applications outstanding with the Canadian government. It takes, in many cases, for over a year. You cannot get on the phone, you can't get a response from the Canadian government on any interpretation issue. As I said before, there's only a very small amount of substantive guidance that's been issued. So I think on the Canadian side, the enforcement problem is, and I mix together enforcement and administration, because it's not just enforcing against companies, it's making sure companies understand what the law is and what the expectation is from government. But because we haven't gotten those right yet, I think we've got a disconnect between the policy and what's actually happening on the ground.
Well, thank you, John. Happily, we have Colin Bird representing the Canadian government here, and he's going to carry your message back to Ottawa, I'm sure.
Or disagree with it.
Well, you can
That's
see
good too.
You can see the vastness of this subject and how important it is in the international trading regime. But I know that Professor Kai Carmody has been itching to ask a question of our panelists. I'm going to turn the microphone over to him.
Thanks very much, Larry. One of the things that, one of the threads that came through in the comments that were given today by both of our panelists pertains to the need for greater cooperation in sanctions administration and probably ultimately in sanctions enforcement. Richard referred in his comments to various groupings that the United States might call on to enforce sanctions, like the G7, the Five Eyes, maybe the Ramstein Group. I'm wondering what effort is being made in both countries to try to better coordinate and align sanctions practice with our major partners in order to ensure these sanctions are effective, because, as all of you will know, there's been a lot of concern about just how forceful and just how effective these sanctions, particularly against Russia, are and are going to be in the future. Thanks.
Rick?
First, let me comment, Kai, on your question. Multilaterally, they're always more effective multilaterally. And yes, that should be something that always is sought, but it's often difficult. For example, you can't go to the UN because it'll be vetoed by Russia or China. It happened when Iraq invaded Kuwait because Russia was boycotting the UN at the time. So that was the first great multilateral program that ever existed. Also domestically, getting the Justice Department on board, it was work to try to get them prosecuting the first case. We too had to put civil penalty authority within the Trading with the Enemy Act. That took hearings, and that took a big effort on my part personally for constantly being a witness on this. And also, the banking community was really shocked when I had the audacity to issue the first civil penalty to a major U.S. bank that had committed a very egregious violation. In fact, the CEO of the bank, along with its general counsel, came in to visit me and tell me how outrageous a behavior this was, shouldn't be expected from an employee of the federal government, that we should go along with the banks, not sanction the banks. Well, that's all history now. But each one of these areas takes work, and it takes commitment. The civil penalty authority took several years to get passed by the Congress, and even then, with right to hearings and right to whatever, not pure civil penalties, but essentially an administrative process that was significant. So I agree, Kai, these are both very important issues that are worthy of further discussion.
Yeah, I think the what I thought of first when I heard your question is the Five Eyes initiative involving Canada, the United States, the UK, Australia, and I believe New Zealand. And that had a lot of traction early on, especially on the anti-corruption side. So, and a quick plug for those of you from Western University here at the law school, we have one of the first courses of its kind in anti-corruption law and policy. I know at least one student is here, where we talk about issues just like this on anti-corruption, where the governments were cooperating on foreign corruption issues. And of course, great interest on the part of the United States to push that forward, because they're the high watermark with the US FCPA, and it's to their benefit from a competitive point of view to make sure that all their trading partners are doing the same thing. So that very much, we saw a lot of that on the anti-corruption side. I'm hearing that it's more like the Four Eyes these days rather than the Five Eyes, because Canada may not be as eager a participant. But on the sanctions side, we haven't seen that. And in fact, in the recent case where a Canadian national was arrested in New York, this was a few months ago, on sanctions violations, specifically evading the Russian sanctions by sourcing US origin product, having it shipped to, I think it was either Hong Kong or Malaysia, and then eventually to the battlefront in Ukraine. That Canadian was arrested, charged. I think there's two of them. They may have done a guilty plea since then. But I understand that was not done with the cooperation of the Canadian government. And they happened to be using a Montreal-based Canadian company to order some of these parts that were being diverted. Now, the parts never went into Canadian jurisdiction, but we are talking about a Canadian company and Canadian citizens, and the fact that there wasn't cooperation between the US and Canada on that, leads me to believe that just on the sanctions side, we haven't gotten there yet, unfortunately.
Larry, can I follow up with that? You mentioned staffing. Staffing was a constant problem at OFAC when I was director. It was always a fight to get more staff, and the administration didn't want to recognize that you need people. I say that in great sympathy to OFAC right now. They've got a huge effort with Russia, and they are working very hard to do their best. But to give an example, every company that trades internationally should have an OFAC sanctions compliance program in place, because if you do business with a specially designated national, you are subject to civil and criminal penalties. It's critical, and enforcement is absolutely necessary. So what's the watchword I would give to a company that's doing business internationally? Know your customer. It's the basic of money laundering. It's applicable in sanctions as well. If you don't know your customer, you don't know where your product is going, you don't know the banks that are involved in finance, you don't know the brokers, you don't know who put the deal together. Everything is critical. Law schools will teach great courses in unfair trade practices. Maybe 2 or 3 firms in New York and Washington have a real specialty in that area. Every law firm that has customers or clients that do business internationally have an OFAC practice. It's across the board, but this generally isn't taught in law schools.
You know, one of the things that Canadians and other countries have learned is that, of course, Washington is the sanctions capital of the world, and it's because the dollar is the global reserve currency, and companies that may think that they don't have a sanctions problem, let's say a Canadian company, because you know, ostensibly there isn't a Canadian sanctions on a particular country, but lo and behold, they may find that they are transgressing American sanctions because they have an operation that puts financing through a U.S. financial institution. So it reinforces what both Rick and John have said. This is a major, important part of international law practice today, and it will continue to be a dominant issue in international trade. One thing, and I know our time is virtually over, one thing that really interests me as a phenomenon, and it was raised a little earlier this morning, we're talking about government, largely about government regulations, laws, etc., international treaty obligations, but there's a whole range of human rights enforcement that comes through private regulation, non-governmental regulation. And in that regard, I think investor pressures are forcing companies with operations abroad to comply with human rights standards. I think this is a phenomenon that isn't much discussed, but it does have an impact on the way human rights are applied by corporations in their foreign operations through investor pressures, call it ESG or CSR, but investors are demanding, and I'm talking about institutional investors, not just private retail investors, investors are demanding that companies in their operations abroad adhere to basic human rights standards. It's an interesting part of the discussion. Anyway, I think I have to. Is there a question? Have we got time for question?
One question. John, Richard, great presentations. My question is, it's a good question that the law students that are currently doing corporate law would love to hear your opinion on this. And it's definitely the idea of corporate versus individual responsibility here, piercing the corporate veil. And that makes, of course, individual board members here and corporations responsible for individual decisions. And there's potentially civil and or criminal responsibility if you can pierce the corporate veil for decisions from a corporation that have a direct and clear impact on a violation of human rights. Can I get your waxed eloquence on what you feel about the piercing of the corporate veil in these situations?
Well, one of the things we talk about in our anti-corruption course at the Western Faculty of Law is I don't want to get too theoretical or in the weeds here, but corporations are artificial constructs. There are people acting behind corporations. There are people making decisions. And ultimately, you can talk about penalizing a company. You cannot put a company in jail. Someone has made that decision to do whatever, whether it was a human rights violation or violation of anti-corruption law. And so we always think about that when we think about the different remedies out there to prohibit this activity or to dissuade companies from engaging in this activity. And interestingly, looking at the new legislation coming out, we'll use the Supply Chains Act as an example in Canada, the requirement to report. There is a requirement in the Act that the report be approved by the directors of the company, by the board of directors, whatever the governing board is. And then that it be personally attested to by one or more of those directors. They have to sign a statement saying that it is true, complete, and accurate. Now again, there you're not reporting that you've done you've undertaken a certain level of due diligence. You're reporting what you did. So it isn't quite as drastic as that sounds, but still that the fact that that obligation is in there, that it's designed that way, indicates that I think from the government's point of view, they are now looking at boards and individuals on those boards to potentially assess liability. And there is a mechanism for imposing penalties for false or misleading information that's provided in those reports, including for directors that would have acquiesced or approved in that process. So I think we're on the way to getting that. On the sanctions side, though, again, it's criminal in Canada, and the same with anti-corruption, it's criminal. So you still, just because the board may have approved a report or approved a transaction that involved corruption or a sanctions violation, you still have to demonstrate beyond a reasonable doubt that the individual violated it with knowledge and intent, mens rea, et cetera. And that's still going to be a bit of a hurdle, I think, without the civil mechanism.
We have a question here, and I think it'll have to be the last question and answer because our time is pretty much exhausted. But go ahead, please.
Okay, well, I'll be quick. But Richard, I'd really like to hear your thoughts on the expropriation or forfeiture and sale of assets, of frozen assets, as Canada has recently done. Are there any international law implications related to the forfeiture, including when there hasn't been a criminal conviction, that would be a major source of concern for you?
To answer your question, would it be a source of concern? The answer is yes. I mean, this is expropriation of private property by individuals that are very vaguely accused of being, a supporter of Putin. The evidence used in such situations is awfully vague. Reasonable cause to believe is now the existing standard. Well, what's the reasonable cause? Well, I read it in the newspaper, and they said such and such and such and such. That's usually the standard that's taken. Now, you're going to, with such an activity, go and expropriate under whose law that person's property within your jurisdiction, under what basis? And those are the issues that I think are real. The U.S. banks are concerned. They had considerable business with Russia at the encouragement of, as did EU banks and Canadian banks and UK banks and so forth. Now the question coming from them is, can we take a set-off? Every single program that OFAC administers has a specific provisions, no set-off. So that means they can't set off against the deposits, and they're going to lose their shirt on everything they left in Russia. So that means the banks will largely take a huge hit if this goes through. So I think these issues really haven't surfaced at a level where they need to surface. So much like the Iran claims settlement in 1981, a program was set up and ratified by the Supreme Court 9-0, under Daines and Moore, authorizing a claim settlement program where assets could be put in a location and claims be brought by both sides. But that's a long ways off. But to expropriate someone's property on the very thin basis now, again, let me go back. There are groups that are trying to get together and just name names. What's the justification? Well, there is none. That's clearly a violation of the Administrative Procedures Act, which doesn't require the same level as it would take under expropriation in the U.S. But there's a whole variety of legal issues that need to be.
You'll also see it come to a head. In Canada, as you may know, we've seized one of the world's largest aircraft sitting at Pearson International Airport. That came after Volga Dnieper, the owner of that aircraft, was put on a sanctions list, and there was a press conference with the Ukrainian Prime Minister where he said Canada's going to give us this aircraft. That aircraft has been seized by the government. They're taking actions now to forfeit it and transfer it to the Ukraine. But Volga Dnieper is using the Russia-Canada bilateral investment treaty to sue the Canadian government for expropriation without compensation. And that process has been initiated, so it'll be played out within the BIT environment as well.
Well, look, we could go on for hours and hours discussing these fascinating issues, and unfortunately time draws to a close. I want to thank Rick Newcomb and John Boscario for a fabulous presentation.